Okay, everyone, I can see we still have a number of people signing on, but it's a couple minutes after noon Mountain Time, and so I wanted to go ahead and get things kicked off. My name is Mark Waletsky. I'm a partner with Holland & Hart, and I'm currently the practice group leader of the Holland & Hart Labor and Employment Group, and glad to be here with my colleagues today and presenting you with some very important Colorado legislative updates today. I have to say, I wish we were able to do this in person. We normally do an employment law update in person, and it's always great to see all of you. But obviously, given the current circumstances, we're not able to do that. But hopefully, this is the next best thing to help keep everyone informed of a number of new laws, some of which are already in effect, some of which are going to be in effect in Colorado in 2021. So we hope you enjoy the presentation. As you're probably all used to by now, we are keeping the attendees muted. But if you have questions, there is a Q&A section, should be on the right of your screen. And if you have questions, please feel free to use that function, and we will obviously do our best to make sure and answer your questions either as they come up, or we'll try to reserve some time at the end as well. I believe we will be posting our PowerPoint to our blog, and our folks will send out some more information about that to all of you who are in attendance, so that if you want to have a copy of the PowerPoint as a reference or check in on any of the links, you'll be able to access that, that information. And I know we have a packed agenda with all of these new laws, so I want to jump right in. But before I do, I want to give a quick introduction to my colleagues who are going to be presenting today. And I'm just going to go in order of presentations. Brad Williams will be our first presenter. Brad is in our Denver office. He is going to be talking about Colorado's new pay equity law that I know a lot of you, or maybe all of you, are trying to figure out how to deal with. And so looking forward to Brad's helpful information on that. Steve Gutierrez and Deborah Hake, also in our Denver office, are going to be talking about the new comps order, wage and hour changes in Colorado that affect really nearly all employees who are located in or have employees in the state. And Steve and Deborah are going to have a lot of helpful information on that new law and that new order as well. And John Husband, our Dean of Employment Law, who has litigated and knows a lot of the all of the key cases and developments in Colorado, is going to be talking about some of the potential new developments affecting Colorado employers, including the paid family leave law that is going to be on the ballot this November. And Deborah Hake is also going to touch on some issues with respect to vacation pay that are percolating through the courts right now. So with that, I'm going to turn it over to Brad. And the one other thing I would note is please keep an eye out for upcoming webinars. This is just the first in our series this fall. We have a number of additional webinars to come. So with that, thanks everyone, and Brad, take it away.
Well, thank you. Good afternoon, everyone. If we could advance the slide, please. Once more. So this is the agenda Mark went over. If we can advance one more, please. So I'm Brad Williams. I'm of counsel at the Holland and Hart in the Denver office. And what I'm going to talk about today is the Equal Pay for Equal Work Act. This is a law that was passed by our legislature last year in 2019, but it's something that's creeping up on employers right now because it goes into effect January 1st of next year. So January 1, 2021, and it's going to apply to basically all employers and employees in Colorado. It's specifically going to apply to violations of the law that occur on or after January 1. So we really just have a few months to get ready for this law, and we'll try and get you ready today. The law does three big things. One, it creates some rules that are intended to create pay parity between men and women. The second thing it does is it creates some rules about posting job opportunities, both internally and externally. It has some rules about what you have to add when you're posting those job openings, specifically some requirements to post information about the pay that's going to be provided and the benefits. And then the third thing it does is it creates some new record retention requirements. And for some of you, it may actually require you to create some new records. We'll talk about that as well, but what it does in that regard is say that you have to have both some job descriptions and wage rate histories for everybody. And some employers, particularly some smaller employers, may not already have job descriptions in place. So that's something that you'll probably need to do before January 1st. So let's just dive into it. The first part of the law, as I said, is really intended to create parity between men and women in the wages they receive. And what it does is prohibit discrimination, wage discrimination on the basis of sex. The objective of the law, as written in the law, is to ensure that employees with similar job duties are paid the same wage rate regardless of sex. And in passing this law, the legislature pointed to some disparities that have existed even since a federal law was passed in 1963, the Equal Pay Act. Even notwithstanding that federal act, which was designed to prevent pay disparities between men and women, women in Colorado today make about 86 cents for every dollar that a man makes. And aggregated over the course of an average woman's career, that works out to somewhere between $400,000 and $1 million. So it's still a pervasive problem, and that's what this law is intended to fix. The law does another thing, which is it prohibits employers from seeking or relying upon an applicant's wage rate history in determining his or her wage rate. And the idea behind this is that a lot of wage disparities are perpetuated over time because somebody will get hired, say a woman will get hired, and in the initial interview, the employer may say, well, tell me what you were making at your last employment. And if that happened to be some amount that's lower than what a man may be making in a comparable position, and the employer hires the woman at that wage rate, and then maybe does incremental raises from there, you can essentially lock into place wage disparities that have existed for a long time. So the first thing the law does is say when you are interviewing someone, you can't seek or rely upon their wage history in determining their wage rate. The law also has very robust anti-retaliation provisions. In essence, it protects everybody, both applicants and employees and other people when they discuss wages with one another. Or if an applicant refuses to disclose her wage history to you, although you're not allowed to ask, again, it prevents you from retaliating or taking any sort of adverse action based on that. As I said, this law applies to all public and private employers in Colorado, something coming up fast that you need to be aware of. We advance the slide, please. So the heart of the law really is this prohibition on paying men and women differently. And specifically, the Act says that employers cannot pay employees of one sex a wage rate that is less than the wage rate paid to employees of a different sex for substantially similar work. When we're talking about wage rate and comparing a wage rate that a man and a woman may get, the law says that you have to take all compensation into effect. So if you have hourly employees, you take their hourly wages into effect, salaried employees, their salary, and all other compensation. That can be things like bonuses or benefits. Now, you can't pay someone, a woman, differently for substantially similar work. Substantially similar work is defined under the Act to be considered without regard to the job title. Meaning if you have two different employees and they do essentially the same job, but they have entirely different titles, that's not going to help you at all. You look at the substance of the job. And when you're trying to figure out if it's substantially similar work, the law says you look at a composite of the skill that's required for the work, the effort that's involved, and the responsibility of the job. And effort can include shift work. If people have to work undesirable shifts, midnight shifts or so on, that can be something that you can take into account. We advance the slide, please. Now, the Act does permit some pay differentials between men and women for substantially similar work, but only in very narrowly defined categories. I mentioned before that this Act follows a federal act that's been on the books for some 60 plus years now. But what it does is it really expands it in ways that make it more robust. And under the federal act is called the Equal Pay Act, employers could justify a disparity in wages based on a number of factors that are set out in the statute or any other factor other than sex. And Colorado's statute is different. It doesn't have that catch-all, any other factor other than sex. Instead, what it does is it lists the specific reasons why you can have a legal pay disparity, but says that that's it. You don't have the catch-all and you can't rely on it. So the specific reasons that will allow you to have a pay disparity is if the pay differential is based on a seniority or a merit system, if it's based on systems that measure quality or quantity of production, if it's based on different geographic locations where the work occurs, if it involves work that requires travel as part of the work, that can be a reason. Or if employees have different education, training, or experience, that can be a reason for the differential, but with a caveat. And the caveat is that the different education or experience or training has to be relevant to the work in question. So for example, if you have two employees who do accounting work and one happens to have a high school degree and the other happens to be a PhD in physics, that's actually not going to help you because the PhD in physics isn't relevant to the work that they're doing. So yes, different education levels or training can help you, but only if it's relevant to the work in question. Now, as I said, unlike the federal act, those are really the only reasons, the only defenses you're going to have if someone sues you and says, I'm being paid differently from a man in my position. And in addition to showing that the differential is based on one of these express reasons, you're going to have to show a couple other things. You're going to have to show that the reasons that you're invoking are reasonably applied. So let's just take an example and say, work that does or does not require travel. If you want to distinguish a woman's job that, say, doesn't require travel from a man's job that does, but the travel is minimal, maybe a trip or two a year, that's not going to fly because the factor that you invoke or the factors that you invoke have to account for the entire wage differential, and they have to be reasonably applied. And then the other thing that the law requires is that the employers show that they did not, in fact, rely on prior wage history to justify the differential. So not only can you not ask people about their prior wage rate history at least beginning on January 1st of next year. If, say, in the middle of next year, someone says, well, I'm being paid differently from a man, and you're going to try and justify it based on one of these listed reasons, you also have to show that when you hired them way back when in the 90s and 80s, whenever it was, you also didn't rely on their wage rate history to kind of set them on a path that then subsequently resulted in lower wages. We advance the slide, please. Now, the second part of the Act, as I mentioned, relates to some job posting requirements, new requirements that didn't exist before. And on the left side of your screen, these are the requirements that you have to put in job postings. These are for both internal and external job postings. So whether you're posting a job internally or externally, the posting now has to include the hourly or the salary compensation for the position or a range of that hourly or salary compensation. It also has to include a general description of the benefits that are offered along with the job. And in talking with some employers about this new law, there are questions about, well, what does the range mean? Unfortunately, that's not something that is spelled out in the law. Currently, the law itself consists of about 10 pages as written by the legislature. We are waiting for some regulations from the agency which is administering this act, the Colorado Department of Labor and Employment, but those regulations haven't come out yet. There were some promises that they may be coming out, but then frankly, COVID hit and pushed back everybody's schedules, including this agency. So it's possible by the end of the year, we may have some better idea in regulations about what the act means by things like a range of hourly or salary compensation, but for now we don't have it. So the best advice on that one for the time being would be, something reasonable. You can't say the salary range is between $1 and $1 million. You really need to make a good faith effort to narrow in on exactly what will be paid. The second requirement with respect to posting is really one that I think is causing a lot of employers questions. And the requirement relates to internal job postings. The law requires that employers must now make reasonable efforts to announce or post a promotional opportunity, or rather all promotional opportunities, to all their employees on the same calendar day. And the posting also has to be done before the promotion decision is made. A number of employers I've worked with have had questions on this. One of the most common ones is, well, if we're going to do this, how long do we have to have this job internally posted before we make a decision? And unfortunately, that's one of the areas that we don't have guidance on. The Act itself says it has to be done prior to making the promotion decision, but doesn't say how far in advance. I think as a practical matter, if to position yourself well to defend against lawsuits on this, you should obviously post it as early as you can, but certainly early enough such that people actually can apply for it and be considered. I think if you do it within that time frame, you're generally going to be safe. Another question that we've been getting from employers about this requirement is, well, what is a promotional opportunity? Let's go back to our example with accountants. Let's say you have a number of accountants at your firm. You can have accountant 1 positions, accountant 2 positions. If somebody is just kind of naturally being promoted in their lines of progression, does that constitute a promotional opportunity? And again, unfortunately, we don't know. It may be something that is spelled out in the regulations, but it may not be. So I think the safest approach for employers to take here is to assume that things are going to be promotional opportunities. Those close calls, if you assume that it is a promotional opportunity, you post it as you're required to, post it in advance of the promotion decision, you're generally going to be safe. There's one other thing which can give you a little bit of assurance here, which is that the law does require you to post these promotional opportunities, but it doesn't say anything about the decision you make about who you're going to promote. So if you have someone in mind that you're probably going to promote, say in his or her line of progression, you post this, other people apply. There are no hard rules about having to promote anyone else who applies, with a very important caveat, which is you can never make that decision in a discriminatory manner. So if other people apply, it turns out they happen to have better qualifications than the person that you were thinking you were going to promote, and you don't promote them and you can't defend it on a non-discriminatory basis, you could very well be open to a discrimination claim if the person who you decided not to promote with better qualifications happens to be in some protected category. But frankly, this can work both ways for you. A lot of employers are viewing this promotion posting requirement as onerous, and it certainly is in respects. But on the other hand, it could very well help you identify someone in your organization already who may be better suited for the position, better qualified than the person you're going to promote anyway. So you're going to have to comply with these new posting requirements, and we'll talk a little bit later about the penalties if you don't apply or don't comply with them. Could we advance, please?
Brad, before you go to the next slide, just a couple of quick questions that I know I've heard from clients that I'd be interested in your thoughts on, and hopefully others are as well. But one is with respect to the range, what are your thoughts? I've had a couple of clients ask, well, what if we happen to get a stellar candidate and we end up needing to pay more than what we published in the range? What do we do? Does that mean we have to go back and republish the posting with a new range? Is someone going to say that we didn't publish the accurate range? And the second question that I've gotten from a lot of folks is, for those folks who may not be based in Colorado, but who have maybe national postings, especially now with COVID, I've been asked a number of times, well, do we have to comply with this new Colorado posting rule if we're doing a national posting? So I would be interested in your thoughts on those 2 points.
Sure. And let me take the second one first, which is if you have an employer who isn't necessarily based in Colorado, who is posting for a job which may or may not end up in Colorado, maybe a remote job now, do you have to comply with this? I think the best answer is yes, you should. And the reason you should is because you don't know who's going to apply. And it could very well be someone who's in Colorado, even if he or she may be working remotely from Colorado. And so if you don't post it properly according to the law and someone from Colorado applies, then you can be on the hook for some of the penalties for posting it incorrectly. With respect to the second question, or rather your first one, I think that one's harder. The question is, what if you make a good faith attempt to define the range and you don't get any takers in that range, and then somebody shows up and they may accept the job, but outside of the range? What do you do? I think there's just no good answer for that now, right now, Mark. It's something we're going to have to litigate going forward. But I will say this, which is, and it actually segues into the next thing I was going to talk about, which are some of the record retention requirements. And one of those requirements is that you keep job descriptions and wage rate histories for 2 years throughout somebody's employment, and then for 2 years thereafter. As I said at the beginning, a lot of employers may not already have these job descriptions in place. Even those that do, this can be a great opportunity to try and refine those. And when you're refining them, one of the things you do, or when you're creating them anew, one of the things you should do is really get granular and say, this is the job. It's accountant 1. Here's the pay for it, or here's the range pay for it. Or accountant 2, here's another range for it. And then you want to stick within that range in all your postings. And so getting back to your initial question, if you do that, if you have these job descriptions in place, They're well-defined. They're things that you stick with. If you were to run into a scenario like you were describing, Mark, where you advertise for accountant 1 and you have no takers, but somebody is qualified, maybe overqualified, you could repost for accountant 2 with that new range and hire them under that new range. That's probably the safest approach, but one way or the other, I think you're going to want to define these ranges of compensation for a number of different reasons under the law. But the one we're talking about right now is because you have to do it, you have to keep records of job descriptions and the wage rate histories throughout somebody's employment and for 2 years thereafter. And let me pause there for a second. We've received a question from one of our clients about when does that start? When does that obligation start? If we have 50, we have 100 employees, they've been employed for 30 years. Do we have to go back and reconstruct job descriptions and wage rate histories from 30 years ago? I think the answer to that is no. And the reason why is the Act explicitly says that it applies to violations occurring on or after January 1, 2021. And that should apply with respect to the job description and wage rate history requirements as well. That's when those go into effect. So fortunately, you're not going to have to go back and reconstruct things in order to comply. Well, let me talk about the reason for the requirements about job descriptions and wage rate histories. The main reason is to preserve evidence for a lawsuit. If somebody sues you, this law and the record retention requirements of the law are intended to make sure that when they sue you, the court and the jury is going to have an adequate basis to figure out, hey, what were they doing? What were they getting paid? So really, that's the reason, the rationale behind it. But let me explain why you want to do it on your own in addition to just complying with the law. The reason you want to do it is twofold. If you don't do it and you're sued, then the judge is permitted to enter something called an adverse inference instruction, jury instruction. And essentially what that does is the judge will say to the jury, look, this employer was required to keep these job descriptions, these wage rate histories. The idea was so that you, the jury, would know what actually happened and can resolve this lawsuit on a good record. The employer didn't keep those records. And so I, the judge, am instructing you, the jury, to assume that if those records existed, they wouldn't have been favorable to the employer. So that's obviously not something you want a judge telling your jury. You want those records there so that the jury isn't permitted to make assumptions about what those records would have said, and more specifically, that what they would have said would have been unfavorable to you. The other reason that you want to have these records relates to damages, which we'll talk about shortly. The damages in the Act, as we'll get to, can include the amount of the pay disparity and then the same amount in liquidated damages, double damages. However, if you're able to show that, yes, you paid men and women differently, but you had good faith that you were complying with the law, that second part, the double damages or the liquidated damages, those may not necessarily be charged against you. And if you don't have these records, the job descriptions and the wage rate history, then you're prevented under the law from showing good faith, or at least it can be taken into consideration as a lack of good faith, which in turn could require you to pay those liquidated damages. Could we advance the slide, please? So let's talk about the last piece of this, which is the damages that you can face. The law has a kind of a 3-year look back period, but it's the statute of limitations with respect to pay disparities is a little unusual. It's a little different from other statute of limitations. A statute of limitations defines the time in which you're allowed to bring a lawsuit after the illegal act occurred. And here what the law says is that every time a woman receives her paycheck, and assuming that it's less than a man's paycheck and you can't defend it on one of those bases that we talked about, that constitutes a separate violation of the law. And as long as a lawsuit is brought within 2 years of one of those paychecks, so the last paycheck which reflects that disparity, the plaintiff suing can go back 3 years from that last paycheck and get disparities, get damages for disparity over that entire 3-year period. As I mentioned before, you can also double that amount. You presumptively do get double that amount in liquidated damages unless the employer can show good faith. One of the ways that the employer can show good faith, and this is something that I think a lot of employers should be looking closely at before the end of the year, is if you conduct a pay audit, a comprehensive pay audit that's designed to determine whether or not you do have people working in substantially similar positions where they're being paid differently. If you do that pay audit and you can point to it to a subsequent lawsuit, that can be used as evidence of good faith, which can get you out of the liquidated or double damages. That pay audit has to be done within 2 years of when the lawsuit is brought to be operative, but if it does, it provides strong protection in one of these lawsuits. And then other damages that are available under the Act include attorney's fees and costs and equitable relief. You see that last one listed. That one can mean the judge has the power to tell you to hire someone, to promote someone, to bring them back to work. So you're looking at both actual damages and then orders from the judge telling you to fix a problem. The very last piece of this relating to fines and remedies under the Act relates to those posting requirements that I talked about, both the requirements to add the salary range and benefits to all postings, and then to to post internal promotion opportunities on the same day to everybody. If you violate those provisions, you can be subject to fines of between 500, it's actually a minimum of 500 and a maximum of 10,000 per violation. And the violation is defined as essentially the job you're posting for. So if you're hiring for, we'll just say the accountant 1 position again, you put advertisements in 10 different newspapers across the state, but you don't have the right wage rates disclosed in there. That's one violation, even though you've posted it 10 times in 10 different newspapers. Same with the internal promotion opportunity. So pretty robust potential remedies, damages under the Act, something that everyone should be aware of, especially coming up on the new year. Let's advance the slide, please. That's all I have. There's one question that has come in. Let me see if I can read it quickly. Otherwise, we'll also take some questions at the end of this program. So the question I got is kind of similar to the example I was talking about when someone is promoted in their line of progression. The specific question is, we promote employees within their discipline when they demonstrate they are at the next level. Do those jobs have to be posted? That's one of those close calls. I think you should. You should do it to be safe. If you post it, as I said, there's no requirement that you necessarily hire anyone internally who applies for it. You may get a better candidate and decide, well, yes, we were going to promote this person to the next level, but here's Sally down the hall who actually has better qualifications for this job. Let's promote her instead. So unfortunately, the answer to that question is it's still unclear. It's probably something that's going to be resolved by litigation in coming years. But for the time being, you probably should post it to be safe. One more question, and then I'll go ahead, Mark.
Let me jump in for 1 second.
Yep.
Go ahead, John.
Equal pay for equal work has been around for a long time, as Brad started his presentation. And that's not a new concept, so I don't think you should be worried about that. It's the other parts of the legislation that you really need to be concerned about, and that's where Brad focused. But let's drop back to that first part again. These cases come down to being a battle of experts, Both sides will have an expert witness that will do regression analysis based on the criteria that you use to defend your decision. And I've been involved in a lot of these cases through the years, and it's amazing when you add factors to why you made your decision. Just education alone is a huge factor. Work experience is a huge factor. Skill and ability is a huge factor. Effort's a huge factor. And when you add those in, it changes the analysis. And what might look like unequal pay for the same work tends not to be. So again, don't worry about that part. Make sure you're meeting all these administrative and bureaucracy requirements. That's where I think is going to be the key for this legislation.
Thanks. And there's just one more question. Let me address this one, and then we'll put off any other questions to the end so that we can get through the other material. The second question that came in is essentially, does the internal posting requirement apply to companies with headquarters in Colorado or any company with a place of business in Colorado? And it's the latter. And actually, to put a finer point on it, it doesn't really matter where the employer is located. It matters where the employee is going to be working. And this is a function of the law's definition of employer and employee. All the law's requirements relate to, an employer must do X, Y, and Z, and an employer is defined as a business or even a public entity that has employees in Colorado. So if you're going to have an employee in Colorado, that's pretty much the trigger. It doesn't matter where your headquarters are. So let me leave it there for now. If we have more questions, we can address them at the end, time permitting. And let me pass this now to my colleague.
Thank you, Brad. The Equal Pay Act sure does look like we're going to get a lot of questions over. So thank you for covering it. I'm going to move on to another new development in Colorado. I say new, it was effective on March 16th of 2020. And I wanted to give a little background before my colleague Deborah jumps in to give some more substantive discussion to the change. In Colorado, we used to have what was called a Colorado minimum wage order. Those orders first started in 1938, and after many, many decades, they had very limited application to employees within the state of Colorado. Following the 22nd wage order, there was a reformation in the applicability of the wage order to employers in Colorado. And that was the first time Colorado moved to define applicability of the wage order to 4 industries within Colorado: retail and service, commercial support service, food and beverage, and health and medical. What followed was some difficult application of those industries to particular job categories. And I think you could sort of see similar difficulties in the way the federal law on wage and hour, the Fair Labor Standards Act, had some difficulty applying itself to the modern job market. And I think that's where the Division of Employment and Labor has decided that the Comps Order 30 was necessary to reflect some changes in the modern workforce. As an aside, I would tell you that we have seen, I think all of my colleagues would agree, a very active Colorado Department of Labor. And so the Comps Order itself is a new revision that has some significant changes. Deborah will talk about the significant ones. I would tell you that there are some changes that are important that I won't spend a lot of time on here, but there was an amendment of what constitutes the employee under Colorado law, under the Comps Order, to mirror that of the Fair Labor Standards Act. Why that's important is you now look to the economic reality of the relationship as the focal point to determine whether you have an employee versus an independent contractor. And that's a fairly broad-based analysis. And so I think we should see some litigation over whether you properly are classifying employees under this comp order itself. One other major change is the employer definition was modified under the Comps Order. Some of you may remember the case of Leonard versus McMorris McMorris was a trucking owner, also known to be a part owner in the Colorado Rockies. That trucking company went bankrupt, and of importance in this lawsuit was the finding that the Colorado Wage Act did not apply to individuals because individuals were not employees. Well, under the comps order, the definition of an employee has changed to adopt the same meaning of the Fair Labor Standards Act. So based on that adoption, I suspect that there is individual liability under the comps order, so beware of that today. I'm going to go ahead and turn it over to Deborah to present a few slides on some other major changes, and then I'll get back to you.
Fantastic. Thanks, Steve. So the key takeaway of this order is the expanded coverage from just those 4 industries that Steve was talking about to almost every private sector employer now. So if we start with the new requirements for employee breaks, at this point, employees who are working in shifts that are more than 5 hours long, they're entitled to a 30-minute uninterrupted and duty-free meal period. This is non-compensated time, but if it turns out that there is no time for a break, employees have to be allowed to eat while on the job and then be fully compensated for that time. Employees are also now entitled to a 10-minute rest period for every 4 hours worked. And to the extent practicable, this has to be in the middle of the 4-hour work shift rather than at the beginning or the end. Now, even though there is expanded coverage, exemptions do remain. The most relevant ones are administrative decision makers, executives, and professional employees that are paid on a salary basis. Now, the salary basis here is higher than it is in the Fair Labor Standards Act. So it's currently set at about $35,000 a year, but starting next year, it'll go up to about $40,000. Other exempted employees, this is a Colorado one, is the downhill ski and snowboard employees that are exempt from the overtime regulations. And also some exemptions that exist under the Fair Labor Standards Act, like for highly compensated employees, do not exist under the Colorado version. So if we advance the slide, please, Chelsea, and turn to compensation. So minimum wage is $12 an hour. Starting January 1st, this is going to go up to $12.32 an hour. Overtime pay is 1.5 times the regular rate of pay for work that's more than 40 hours a week, 12 hours in a day, or 12 consecutive hours of work. So this is also different from the Fair Labor Standards Act that has overtime only for the 40 hours per week standard. Time worked is also different under Colorado law when you compare it to the Fair Labor Standards Act. So under this comps order, time spent on the employer's premises doing donning and doffing work of work clothes or gears, that has to be compensated. Other time that has to be compensated is time spent going through security checks or time spent waiting for a job assignment at the beginning of a shift. And finally, some travel time must also be compensated. This is travel time that is spent for the benefit of the employer, but it doesn't include normal commuting to work time. And now I'll turn it back to Steve.
Thank you, Deborah. I think it's accurate to say that we should expect the state DOL to be fairly active in enforcement. You'll recall several years ago, I mean, more than several, I guess now, but that the state DOL does have the authority to pursue complaints on behalf of an aggrieved employee for all wages and compensation owed, and that certainly applies under the comps order itself. I think importantly, I want to make a couple of points and then turn it over to Mark. The move away from specific identification of who is covered under the order to a presumptive coverage, I think is telling of the direction our state is going. And that should be sort of an indicator that we need to take serious this presumptive application, and that it'll likely be our burden as employers to prove that someone is not covered by the order itself. Finally, as Deborah mentioned, the fact that the salary basis, while it's set at the federal level today, will phase in and rise over the course of time, you need to be mindful of. I don't know when we should expect any revisions to the FLSA salary number, but the state certainly, in both the minimum wage context and now in the context of the salary basis under the comps order, that's important. And then I think, as Deborah mentioned also, the fact that the federal de minimis rule is expressly not applicable to employees in Colorado, that's important. If you have employees who you presently don't compensate for activities like donning and doffing because either you have authority that it is de minimis, note that the division takes the position that the de minimis doctrine has never applied in Colorado. It certainly doesn't apply expressly under the comps order, and therefore any work time needs to be compensated. So that's a finer point to the de minimis rule and making changes in that regard. So what we will defer questions then to the question period, and I'll turn it over to Mark Waletsky. Thank you.
Thank you both very much. Before I go on to my subject, I just want to ask Steve and Deborah, what are your thoughts on how this new comps order might impact litigation that Colorado employers might see? I know a lot of the time in the past, we were primarily dealing with FLSA claims under federal law and federal court, but would be interested in your thoughts on how this might impact either your expectation of the number of claims or the forum in which those claims might be resolved.
I'll take this one, Deborah. It would be my view that the comps order, in addition to what Brad talked about, the Equal Pay Act, will likely increase the amount of litigation in our state court system. Our federal court, I think, routinely has been a difficult place to litigate state claims under a supplemental jurisdiction theory. Certainly, to the extent the FLSA covered, that was a preeminent and primary issue in those lawsuits. If a plaintiff can get this into state court and have an incentive to litigate it based on the remedies provided, like the comps order provides under the Wage Act, I'm guessing we should see some amount of litigation growth under this area of the law.
Great. Thanks, Steve, and thank you, Deborah. Very helpful information. And just a note, I know there was a participant or attendee who had asked a question really directed toward Brad. I think it came to me from Chelsea about reclassification and whether that counts as a promotion. And we will definitely get to that before the end. I'll just note, I think as Brad mentioned, there's really no good definition right now of what constitutes a promotion, and there may be differences between a reclassification where someone is simply being bumped up a level based on years in the job, or getting an increase in pay because of years on the job. That may not qualify as a promotion, but my view, subject to all the other panelists' input when we get to the end, is I'd always be very careful about making sure that your pay equity stays in line, and if you are not doing audits or reviews of that, something definitely to be considered doing going forward. So let me go ahead and jump into the Healthy Families and Workplaces Act, which provides for paid sick leave for Colorado employees. Chelsea, can we advance the next slide? So the HFWA, as I refer to it for shorthand, really has three parts. The first part is effective really from the time it was passed back in July through the end of the year, and that incorporated the Emergency Paid Sick Leave Act from the Families First Coronavirus Response Act. And that allows for up to 80 hours of paid sick leave for COVID-related issues, which we'll talk about in a minute. And then beginning on January 1 of 2021, and then expanding after that the following year to more employers, the Act provides for employers requiring them to provide up to 48 hours of paid sick leave for their employees. Initially, this next year, it applies to those employers with 16 or more employees. And then beginning the following year, it applies to all employers in Colorado. And then lastly, the Act provides for paid sick leave during a public health emergency. For those of you who have operations in multiple states, this is probably becoming more familiar to you. A number of states and frankly a number of cities have incorporated paid sick leave laws. Especially in California, there's a number of cities with different laws and different requirements. This unfortunately adds to the patchwork of that, but for a number of you and a number of policies that I know I've reviewed, in large part, you're probably already compliant. It's around the margins where you may have to make some changes. Can we go ahead and advance to the next slide? So let's start with the first part, the emergency paid sick leave portion that goes through the end of this year. The reasons for paid sick leave really have to do with COVID symptoms or seeking a medical diagnosis for which someone would receive full pay for up to the 2 weeks. If someone can't work because they're either subject to a quarantine order or advised by a healthcare provider to isolate, again, they're entitled to up to their full pay for that period. And then caring for someone due to COVID, including a child whose school or child care place of business is closed or unavailable, they're eligible for up to 2/3 pay for that up to 2 weeks of paid sick leave. So these are all, for those of you who are already subject to the FFCRA, the Families First Act, this is really nothing new for you. What this really does is for those employers who had 500 or more employees and therefore were not subject to the Act, they're now subject to these provisions. Just want to make clear, though, the Families First Coronavirus Response Act also contained expanded paid family medical leave. Colorado did not adopt that. Colorado adopted only the emergency paid sick leave portions of that federal law. And again, it's up to 2 weeks or 80 hours. That's obviously less if you have a part-time employee who regularly works 25 hours a week, then that would be 50 hours for that part-time employee. Can we go to the next slide, please? So starting in 2021, that's when things change, really go on a go-forward basis. Employees are entitled to at least 48 hours of paid sick leave, 1 hour for every 30 hours worked, and at least or up to 48 hours can carry over into the next year. And one thing that I've seen already in the policies that I've been revising for clients, some clients have a waiting period. You can't have a waiting period for this sick leave. So if your policy has that, you need to take a look at it and make some revisions. And this is available to all employees. Again, I've seen some policies that provide paid sick leave only to full-time employees. And again, this applies to all employees. Can we go ahead and move on to the next slide? The other, when I mentioned kind of around the margins of making some changes, so the amount of paid sick leave, 48 hours, all things being equal for most employers that I deal with is probably not going to be a huge deal either for those who have PTO policies or separate paid sick leave. But here's where things start to change. The reasons for the paid sick leave may be slightly different than what you've outlined in your policy. And this law has it broken up into two different parts. The first is those applying to some type of sickness, mental or physical illness or injury for either the employee or the family member, medical diagnosis, care or treatment, and preventive medical care. Those are all fairly typical, but Chelsea, if we can move on to the next slide, you'll see that these reasons sometimes, these reasons are not always reflected in a typical policy because this really applies to if an employee or family member is a victim of domestic abuse, sexual assault, or harassment, and they need leave related to that, whether it's to seek counseling, legal services, medical attention, or whatnot. That is covered by this new sick leave law. So again, if you have paid sick leave or PTO and people are accruing right away and they're accruing enough, just be sure to look at the reasons for which they can take the leave and make sure it's clear that they can take leave for all of the reasons that are covered under this new law if you are covered by it either starting this January or next January. We move on to the next slide. So a few other issues with this law, and I should caveat that kind of similar to what Brad mentioned at the beginning, we don't have regulations yet for this law. And when we get them, that could obviously create some additional need to review and revise your policies. So stay on the lookout for that. But for right now, I just wanted to highlight a few things in this law to be aware of. One, as has always been the case, you're not required to pay out unused sick leave. Now, let me just put a caveat to that, which is if you have a PTO policy which combines vacation and sick leave, this law doesn't purport to change that. This simply says if you offer paid sick leave consistent with this law, then you don't have to pay out that unused sick leave at the time of separation. Another change is that if there's a break in service of less than 6 months, you need to reinstate the employee's accrued paid sick leave under this law. So if someone is laid off, if they're terminated, whatever it might be, then and they come back within 6 months, then you need to reinstate. And I did just see a question, if we do not offer sick leave specifically but have PTO, is that okay as long as we abide by the amount and reasons for leave? Absolutely, that's fine. As long as you are complying with this and allowing people paid leave consistent with this law for the reasons that it requires, then you're fine. It does, though, impact the potential payout, and I know Deborah is going to be touching on that issue of payout of accrued vacation in her segment at the end as well. So that's one thing to keep an eye on. There are some special rules for calculating pay for employees paid on a commission, and I'm going to give you a really short summary, but if you have folks who are paid on a commission, please either look up the rule or call your counsel. The short story is it's got to be the greater of the minimum wage or an average of their commissions over a period of time. Basically, they are not going to be allowed to be paid less than the minimum wage if they're not getting many commissions. Make sure you're maintaining health information separately. You may get health information from employees because when they apply for this leave, they may provide that information to you. You may require it, just as you would with the FMLA. Maintain it separately and securely. And as always, no paid leave if the entire business is closed, but if it's closed due to a quarantine or isolation order, then they may be entitled to that leave. And one other thing I want to mention, it's not on here. One thing that was clear under the federal law, and I think should be clear here, is this applies if someone is unable to work, period. If they're able to work remotely, then that doesn't mean that they're entitled to leave. This is for when folks can't work. Either you don't allow them to work remotely, they can't work remotely, whatever the issue is, they just can't get any work done. There's a question from someone, this is a great question. How does this law work with unlimited time off? That's a great question. I don't know that we have a solid answer, but I'm going to give you my take on that. And if the other panelists have a different view, let me know. I view unlimited time off policies really to apply more specifically to unlimited vacation. Typically, that's what they're designed for, is vacation, not to address what could be a more lengthy medical illness or something like that. And if your policy tracks that, then the unlimited time off really wouldn't cover this. If your policy is just you can take whatever time off you want, there's no caveats, it's always going to be paid, then I think I would probably just be very clear with folks to say the law requires that you accrue at least 48 hours of paid sick leave. Under our limited time off policy, we comply with that. You will have paid sick leave, an amount that is at least equal to what is required under the law and for the reasons that are allowed under the law. I don't know if any of the panelists have a different view on that, but I think as more and more companies go to unlimited vacation or unlimited time off, those types of questions are going to continue to pop up in my view. We could go to the next slide. So the last piece of this new law has to do with a public health emergency leave. I will tell you it's a little bit unclear to me. I think that this really applies beginning Jan 1 because we already have the incorporation of the emergency paid sick leave from the FFCRA that's in place through the end of this year, which covers essentially the same thing, including a pandemic. But this really applies going forward as well. So if there, eventually we will get through the coronavirus, if there is another pandemic, if there's an act of bioterrorism, if there's some other public health emergency, employees are eligible for, entitled to paid sick leave, 80 hours a week for those who work 40 or more hours, and it's less than that for those who work less than 40 hours a week. And again, there are specific reasons and eligibility factors for the leave, very similar to the emergency paid sick leave that goes through the end of this year. So just be aware that even though that emergency paid sick leave portion of this law sunsets on December 31st of this year, we will have this public health emergency leave provision that applies. And one other thing that I wanted to mention, if you have already allowed people this year, let's say 80 hours of time off for a COVID-related reason that is listed in the Healthy Families and Workplaces Act, this doesn't mean you have to go back and allow them another 80 hours. You can get credit for the leave that you've already provided, but if there's some dispute about whether the leave was really for one of those purposes, it wasn't documented at all, your safer bet is probably to allow the leave to avoid a dispute. Now, every case is going to be different, but that's just something else to keep in mind. Is there's not supposed to be double dipping. It's really meant to just ensure employees have a baseline of some paid sick leave for these reasons through the end of the year. Can we go on to the next slide, Chelsea? So here are some links for the poster, which is helpful, I would have put it up, but the print is so small, no one would have been able to read it. But please feel free to go to that link or email me and I can send you the link. There's also some interpretive notices and opinions, and in particular, there are 2 interpretive notices. I think there's number 6A and number 6B, and those really answer a lot of question in lieu of or in the absence of regulations on this new law. 6A addresses the law that's in place through December 31st, basically the emergency paid sick leave for COVID-related reasons. And guidance 6B addresses the law going forward starting Jan 1, 2021. And obviously, as Brad mentioned, we're still hoping for some regulations. And hopefully those will provide some additional guidance as well. And with that, I'm going to go ahead and turn it over to John and Deborah. And again, if there are more questions, keep them coming. We will do our best to get to all of them at the end of the presentation.
Yeah, thanks, Mark.
Thank you.
And let me say, I wrote an article for the Colorado Lawyer on Mark's segment, and we will post that on our webpage. We'll also send it around to you when it gets published. But I asked for authority to send it, and they're very picky about passing the article around before it actually goes in the issue of the Colorado Lawyer. So very interesting topic that I'm going to address. It's in addition to what Mark just talked about, which was very significant. I mean, paid sick leave is something that not a lot of states have. Democrats have tried for 6 years in Colorado to have some sort of paid family and medical leave act. They've failed. Our Democratic governor has not wanted to have a big bureaucracy set up around paid family and medical leave. And he's basically sent it back to them every year. Well, their frustration boiled over, and through an initiative process on the ballot this year is Initiative 283. And Colorado politics are always very interesting, this year in particular, but this is an issue that's not gotten a lot of attention, unfortunately, because it's going to have a big impact on employers. And for example, today I was talking with 2 what I would consider very sophisticated clients of mine and asked them their thoughts on Initiative 283, and neither one of them knew anything about it. So this is something that we're going to talk about right now, but you ought to get the word out if you're in favor of this or against this, and express some of your views on it. They did get 137,000 signatures to put this on the ballot. And if passed, it would create a paid family and medical leave program. Now, to show you how progressive this is, there are only 4 other states in the union that have these. And when I tell you, you won't be surprised at those states. It's California, New York, New Jersey, and Rhode Island. The program would create 12 weeks of leave for employees, plus an additional 4 weeks or 16 weeks if it's pregnancy or childbirth related. It would start in 2024. As far as the benefits go, the benefits would be significant, up to $1,100 per week in the first year, and then 90% of a regular wage rate in 2025. It would cover a lot of the things that the federal Unpaid Family and Medical Leave Act has, but it covers, for example, birth, adoption, foster care placement, care for a child during the first year that they're home, care for family members with serious health conditions, and of course, cover the employee's own serious health conditions or an emergency situation. So I can only imagine what emergency situations you'll all be facing if this passes. But the way it's funded is very interesting. It'll be almost 1% of the workers' wages. They kept it just under 1%, I think, So, it appears less, 0.9% versus 1%. But it would be a 50-50 split between the employer and the employee. And this will fluctuate up or down depending on the experience factors, but it would cap out at 1.2% of an employee's wages. There are opting out rights, and there are also things for fewer employees per employer, but it would definitely create a big state-run bureaucracy. There's no question about that. They're projecting the first year would be $1.3 billion under this program. So, like I said, this is a very big program. Governor Polis, for the 6 years, rejected it. He didn't like the public option. He wanted a private option. But now it's on the ballot, and we'll see what happens. So Deborah is going to talk about some other things to look at coming up.
Absolutely. Thanks, John. So since the pandemic has begun, there have been a lot of new types of employment lawsuits that have been filed all over the country. So this is just a scattershot of some of the more interesting ones. So first up, we've got Amazon and McDonald's. So in these cases, workers sued their employers, accusing them of prioritizing productivity over worker safety. The McDonald's complaint in particular discusses reusing dirty masks and gloves and working in cramped spaces. The claims are that the workers aren't being protected and that the employers are a public nuisance by allowing this to continue. A lot of these suits are being filed amid inaction by OSHA. The agency has only issued a few citations and hasn't conducted many on-site inspections, even though they've gotten thousands of safety complaints. That being said, this week OSHA did issue a $15,000 citation to JBS up in Greeley after 6 workers died and nearly 300 were infected. Next up, we've got the meatpacking workers who want an OSHA citation, saying that the company allegedly failed to protect them from COVID-19. So the employees are suing the Department of Labor, saying that the OSHA agency acted arbitrarily or capriciously and failed to help them. We've got enterprise workers who are challenging layoffs. The Worker Adjustment and Retraining Notification Act, this is called the WARN Act, it requires companies to give workers 60 days of notice before enacting a mass layoff. So this lawsuit is a class action. The employees are saying that the company violated the act by laying them off with no notice in late April, when, according to the employees, the company should have known that it would have needed to lay off those workers after it furloughed a lot of people back in mid-March. Enterprise is citing a WARN Act exception, which shields businesses from suits over mass layoffs when the need to let workers go is unforeseeable, like the pandemic that happened. Plaintiffs are saying maybe the layoffs were unforeseeable back in January, but not by the time March rolled around. Last, we've got right to remote work. So in June, an engineer accused his employer of disability discrimination under Massachusetts law, which echoes the Americans with Disabilities Act. He's saying that because they fired him after he requested to work remotely, that violated his rights. In the past, courts have been skeptical of requests for remote work as an accommodation, but the pandemic may have shifted that now that we know that remote work really is possible. So we'll have to see how this case and the others play out over time. Yes, if you can advance the slide, please. So one other...
Deborah, let me jump in real quick. I think 2 areas to watch out for in the coming days that I think are going to be very litigation prone are discriminatory layoffs. I think we'll see a lot of litigation over that, and wage hour claims with remote work. I know you all are very careful with your employees when they're at work at the fixed location, but now that they're working remotely, how are you tracking their time? When are they taking their breaks? When are they taking their lunch period? You know, are they watching soap operas all day and not really working? So those are all issues that I think are going to come to the forefront. We're seeing a lot of those cases filed in California already, and I think we're going to see more in Colorado in the coming months. So be careful in those areas.
Absolutely. So if we switch over to the vacation pay policies, the Colorado Department of Labor and Employment has issued a regulation stating that use it or lose it policies are prohibited and that accrued vacation has to be paid out if an employee is terminated. So in other words, right now, an employer can't have a policy that states that unless an employee uses his accrued vacation by a certain date, the employee loses that vacation. And if an employee leaves a company, an employer can't have a policy that states that the employee doesn't get paid out for the vacation pay that the employee has accrued. But an employer and an employee can still agree to a lot of other things in this area, including whether an employee is entitled to any vacation pay at all, the amount of vacation pay per year or other period, whether vacation pay accrues all at once, proportionally each week, month, or other period, and whether there's a cap of 1 year's worth or more of vacation pay. So employers can have policies that cap employees at a year's worth of vacation pay, but that don't forfeit any of that year's worth. We can switch to the next slide, please. So that's the status quo, but there are two key challenges to what's going on right now. So first is Nieto versus Clark's Market. In this case, the Colorado Court of Appeals held that it was lawful for the employer to withhold an employee's accrued vacation pay when the employee left the company, because there was a policy stating that vacation pay would not be paid out because of the circumstances in which the employee left the company. So this holding is directly contrary to the regulations that I just talked about that mandated that accrued vacation has to be paid out upon termination. The Colorado Supreme Court granted cert in this case in April of 2020, and so this is definitely a case to watch, and hopefully we'll have clarity soon on whether the regulations stand or if employers can once more decline to pay out for accrued vacation. The other case is Blount. This is an appeal of an administrative decision by the Colorado Department of Labor and Employment that held that it was unlawful for an employer to refuse to pay a former employee for her unused vacation allowance upon her termination. Now, oral argument in this appeal happened just a couple of days ago, and so we're awaiting the decision from the court. Takeaways from this: no more use it or lose it policies, at least for now. Pay out vacation pay that's been accrued at termination. And if you want the ability to limit that pay, you can put in place an agreement stating that your vacation pay accrual is capped at 1 year's worth of vacation pay. And now I'll turn it back to John to talk about labor cases to watch.
I know a lot of you have seen Scabby the rat around town. Scabby is a fixture at a lot of construction sites, but we get a lot of questions about Scabby. Hey, can they do this? Scabby's out here. We have no dispute with this labor union, but there Scabby is and scaring away all our customers. A big case that's coming up, and remember, labor law is very politically oriented. Right now, it's a Republican National Labor Relations Board. Come November, it may be a Democrat board again. But the Republican board is saying, hey, this mobile rat is really engaged in secondary boycotting activities, which is illegal. And we'll see if the courts can agree with that or not. But the counter argument is, hey, as a labor union, we have a First Amendment right to talk about our issue, and this issue is important to us, and we really aren't trying to do a secondary boycott. We're trying to deal with the primary employer in this case. So it's an interesting concept, one that goes back and forth with the politics of our country, and be on the lookout for that. Scabby may be back in play, or he may be put back in the warehouse. We'll see. Okay, I think, Mark, that's the end, and we're ready for questions, right?
Yeah, I think so. I just wanted to, number one, say thank you Thank you to all the panelists, Deborah, John, Brad, Steve. That was all incredibly helpful. There's a lot of big changes as they talked about. Number two, I want to give a shout out to Brad and to Steve. They're behind the or arguing the Blount case, and Brad just argued that in front of the Colorado Court of Appeals. So we have local or immediate expertise on this from our panelists, which is always good. I know we do have some questions. Before I get to those, I just wanted to note that we've got some information on these topics on our blog, and you can see how you can get there. There's some articles here that may help. I will tell you, one of the questions that comes up really frequently has to do with the thorny topic that Deborah just addressed with vacation, and that Brad and Steve have been dealing with in the courts and with the Colorado Department of Labor and Employment. It's tough. I think, and we have a question here about, paying out accrued PTO upon termination, but allowing a carryover of a limited amount from year to year. Again, I invite all the panelists to weigh in on this. What I would say is, unfortunately, right now, we've got some risk for employers who do have either limited rollover amounts where folks are not able to roll over an entire year's accrual, or don't have a maximum accrual until the Colorado Supreme Court rules in the Nieto case, or depending on what happens in the Blount case. I just think there is a little bit of risk there with those types of policies. And I don't know, Brad, I'd be interested in your thoughts, since you're much closer to this issue than I am, but do you have any thoughts or expectations on when the decision from the Colorado Supreme Court may be issued in Nieto? I have been assuming it won't happen until 2021, and probably not until summer, but I'm interested, and I'm sure our attendees are interested in your view on that as well.
Sure. So as you said, I actually handled an oral argument in one of these cases a couple days ago. I've looked at the Nieto Supreme Court docket in advance of that. It looks like most of the briefing is in by the parties. A number of amicus brief, friend of the court briefs have been filed. There are requests for oral argument in the case. I didn't see that had been granted yet. So I think we're still out even from oral argument, and then it'll be some time after that before the court rules. So I think your guess of sometime mid-2021 is probably a good guess. I can address a little bit more a couple of these questions that have come in relating to the vacation time and PTO. One of them is essentially, how can a lose it or use it policy be disallowed, but a cap on vacation accrual be allowed? And that's a great question. And I think that's, one of the arguments that we have made to the court in these cases, and that other parties have made. Taking a step back, what the statute says is, in essence, that any earned and determinable vacation must be paid out at separation of employment if it's earned and determinable in accordance with an agreement between the parties. And the CDLE, the Division of Labor Standards and Statistics, has taken the position that statutory language means that anytime somebody earns vacation or accrues vacation under a policy, that it's locked in and they can't be divested of that vacation under any circumstances. And so that's really how the regulation that Deborah was talking about purports to parse that difference. What the regulation says is that you can have a cap on the accrual of vacation of 1 year's worth or more, but you can never take away vacation that's already been earned or accrued. So unless or until that regulation is invalidated, I think the way to address these, and this may resolve a couple of the questions we were asked, is make sure that if you have something that looks like a use it or lose it policy, it's really a cap on accrual. You're limiting people. They can only accrue 1 full year's worth, and it has to be at least 1 full year's worth. Once they accrue that, that's where they're capped off. But if your policy looks different from that and says, let's say your full year's worth is 60 hours of vacation, but at the end of the year, you can only roll over 40 of it. That's not going to fly under the regulation as written. You would have to write it such that you're capped out at that 40 hours or however much you want to be able to roll over. So that may address some of these questions. I see there may be more coming in, but hopefully that provides a little guidance. I agree. I think that, the arguments we've made in that case is that the statute does and should allow employers to define the nature of vacation policy. The Court of Appeals has accepted that in 2 different cases. But as Deborah said, now it's going before the Supreme Court, and hopefully we'll have some resolution on it maybe by mid next year.
Thanks, Brad. And I know we're just about out of time. I'm going to try to hit a couple of the other questions that came in quickly. One was whether employers over 500 have to pay 2/3 pay if a school is closed under the Colorado HFWA, the Healthy Families and Workplaces Act. For employers, whether you have 500 or under 500, the Colorado law says if your employee needs time off to care for someone or to provide child care because a school is closed for COVID-related reasons, that's paid sick leave at 2/3 pay. There was also a question about using an external recruiter and whether you're required to post internally and provide a wage range. Brad, if you disagree, let us know. But my view is it doesn't matter if you use an external recruiter or if you do it internally. The law is the law. If there's a promotion or a job posting, you have to comply with the law. So I would be sure if you use an external recruiter that they are complying with this new law come Jan 1, 2021. And the only other one I wanted to mention, which I touched on, was there was a question about reclassification or a bump in pay. Is that really a promotion if someone is moving from accountant 1 to accountant 2? I think, as Brad mentioned, you're going to want to be careful with those, because if you define promotional opportunity too narrowly, you may get yourself into trouble. But if it is truly just a reclassification based on years of experience in the position, it's not a promotion, for example, from controller to CFO, where you're expanding duties and responsibilities, then my hunch is that the regulations are going to say that's not the type of promotional opportunity that we're talking about. But until we get those regulations, it is a little bit of a guessing game on that point. And I'm hoping we covered all of your questions. I see it's 1:30 on the nose. If there are other questions, please let us know. I'm happy to stick around for another couple minutes. In the meantime, I just want to say thank you to all of you for participating. I hope that you're able to participate in our future webinars, and I hope this was helpful. Please feel free to send us any feedback, or if there's particular topics that you want to see. We're always happy to take a look at those. So again, thanks everyone, and to the panelists, thanks to all of you for covering all of these topics.